Hello, everybody. This is John Waite coming to you on behalf of NC Realtors. And as you all are well aware, we are here to talk about the newest round of forms changes this cycle. Some of you, I can tell, some of you are the kinds of people who open a present on Christmas Eve. Now, I'm not judging you. Sorry, no, I'm totally judging you. But the reason I know that is because a couple days ago in the Q&A section of the website, there we posted the form summary Q&As, and some of you who are forms nerds like myself went ahead and dug into it and gave a lot of really good feedback already, and really appreciate that. Actually, anytime you have feedback, you can call the legal hotline. You've been giving feedback already on the forms, but let's go ahead and take a look well, hold on, a couple other housekeeping matters before I go ahead and get into that. First of all, this whole thing, echo, hopefully no echo, will be recorded and posted on the YouTube page. So make sure that uh, if you miss something or you don't get it or whatever, or if you're having technical issues, I feel fairly confident the YouTube version will be okay. And if the YouTube version is not good, I will re-record this whole thing. I don't care. I talk all day anyway. What do I have to do? Nothing. All I have to do is talk to you people about forms pretty much all day, every day anyway. So if I got to re-record it, I'll re-record it. In any event, will be recorded and posted. You guys will be sure to get a copy. It'll be emailed out, blasted as well. So there's really no way to avoid me when you think about it. It's kind of like, I'm inevitable or something like that. Forms are inevitable. You can play around with that, workshop it as you need to. But yeah, so don't worry about that. You will be able to have access to it. A couple other things to keep in mind is that there is a contracts class coming up, the perfect road to the contract, and legal risks class. So if you did not get enough of my nasal Midwestern accent, then you can do that. And you can sign up for those classes. And a lot of the things that we will cover in here will also be able to be covered in there. In addition, in particular with the legal risks class, that is something that covers everything from scams to antitrust to everything else. Basically, you know how you go through your pre-licensing and you get all that information, you go out in the wide world, and basically you have no idea where all the landmines are once you once you start. Like pre-licensing, is really about you get the basic nuts and bolts, right, of how to be in this business. All the things that you learn along the way through hard knocks, that legal risks class is really designed to cover that. And for those of you who don't know, I'm one of the attorneys that does the legal hotline for NC Realtors. I'm one of four of us that are in the office that do the hotline for NC Realtors. And really that class takes all your horror stories from the hotline and puts them into one class where you can do it. Now, if you're a BIC, I think that I would really, really recommend that you have any of your new agents at least consider taking that class. It's a really good class to help them know where landmines are as far as contracts go, scams go, things like that. Another thing to keep in mind is that there are NC Realtors is doing a really good job of pushing out this year of just materials and things that BICs can use. One of them will be coming up at convention, something that it's going to be focused on when you are faced with like a threatening letter or say an ethics case or even a real estate commission case, then what are the ways as a BIC to really efficiently handle those and hopefully help you sleep better at night, knowing that you've got the right mechanics in place to help deal with those things. Those things will all be coming up. So keep a lookout for those things. If you're not paying attention to the Realtor Rundown, that's a real good way to keep up with the latest information. All right, now let's go ahead and start with the website. Because if you want to follow along today, you totally can on your computer. You could just turn my voice off if you wanted to. Some of people who would do that, you're probably the people who like, you have the game on the TV, but then you have a separate feed for your favorite announcer or something like that. I I've never been able to do that, but I do understand the allure. Sometimes the announcers can get pretty aggravating. So in any event, if you want to do that today, you can. If you hover over legal and ethics, so this is ncrealtors.org. If you hover over legal and ethics, you can see legal Q&As right here. And when you click on that, It'll take you over to the Q&As, and you can see that on May 27th is when all three of the summaries were uploaded. And interestingly, they're in the main feed for the Q&As right here. The Q&As come out every Monday in the rundown. If you're not following that, feel free to subscribe to that. Highly recommend it. Even if your email's a little bit overloaded like mine is, it's something that you can definitely keep track of. If you want just major highlights, major bullet points of what's going on in the industry or at the state level, it's a good place to go. And as far as summary of forms changes, you can see over here, there's these categories of different forms. And I'm sorry, but my computer's being slow. In any event, you can see if you really want to get forms, if you really want to go down the rabbit hole, you can go here and see forms changes, those summaries all the way back to 2021. There are more. I mean, honestly, I'm not going to give them to you because, at some point, you really got to think about getting help. Like if you're really into forums that much, either that or you come take some hotline calls. We have plenty for you. All right. So this is where we are going to be today as far as going through the forms changes. I'm going to go back to the main screen here. I hope. Here we go. And when you click on the 2026 residential forms, that's where we're going to be operating in today. And so when that comes up, hold on, it'll show you the hyperlinks here in just a second. I'm not sure why my computer's being so slow, but all right, well, it'll get there eventually. In any event, when you click on this, it'll take you to the Q&A. The Q&A has an explanation of the forms changes, and it also has the links to the things that we're about to go through, which is the new forms. Now, for those of you who have been with me the last couple of years going through these forms changes, usually I like to start with the offer to purchase and just kind of go through them that way. However, even though there are really good things, yeah, there we go. If it went, there we go. All right. So you can see here, these are the hyperlinks. In any event, we're not going to start with the offer to purchase this year because I just don't think that's the best place to start. Let's start with probably the biggest change, okay? The biggest change is right here, and it is the new Form 220, okay? Now, you can see, first of all, at the top, in the title alone, you've already got a pretty significant change where now it is designed and it is to be an actual addendum. You can also see that it's just to be used when the seller is providing a credit to the buyer, and that credit being specific to this form. We're going to talk about other seller concessions in just a minute. But you can see the new 220 has a couple things missing that are not in the old form. For example, you can see in the first paragraph, there's no more checkbox for buyer and seller. It is simply a credit from the seller to the buyer now, and it is part as an addendum to the contract. Okay, it is a contract term. You can see that the other languages in there. There's no date in paragraph 3. There's pretty much none of the other stuff. And why is that? Because listing firm is no longer part of this addendum. You can see buyer and seller can sign right here, and that's it. One more thing before I keep going, because I'm sure there's probably already some questions. We're scheduled for an hour and a half today, okay? So I'm going to go through, and then we will do questions at the end. It may well be that I'll answer your question down the line anyway, because just the way that I need to go through these forms changes, it's going to require a little bit of overlap on some of this stuff. Okay. In any event, this is the new Form 220. It is meant to be incredibly simple. Now, some of you may be wondering, well, why didn't you just put it into the contract? That was a proposal. It was heavily discussed. I can tell you that Forms Committee and Joint Forms Task Force both spent the entire year debating how to address this topic. Ultimately, the buyer agent compensation being in 2T or 12T itself was not approved by everybody altogether. That's fine. Could it be next cycle? Yes, it could be. But for right now, for this cycle, what we've got is a revised 220. And in any event, you can see it is approximately a million times better than the current 220 you're using. Hopefully, from the time 220 was revised to address the settlement and the changes to the MLS rules, from the time that happened until today, which we're coming up on 2 years, okay? There's just been a lot of questions on how to fill out 220. Some of you have excellent processes in place and it's not been a big deal. Sometimes people with the way it's just with the way your market works, it was a little bit different. People did it different ways. That's all fine and dandy. But you can see that, and also understand this, that Form 220 was never meant to be an addendum to the contract. That happened last year when there's a change in the law. Prior to that, you couldn't have Form 220 attached as an addendum, which created the biggest problem, which was if you sent 220 and the contract at the same time, and there was a change to 220, but not to the contract, but the seller signed everything, then did you have a contract or not? And honestly, when it came to the hotline calls and addressing those sorts of questions on the hotline, it was a very fact specific question. But sometimes the answer was maybe. And sorry, but that's just no, 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 no. We can't be having that. Your guys' lives revolve around are we under contract or not? And so to ever have a scenario where there's just a question of whether you're under contract or not, just because of the way agent compensation was being negotiated, was something that the forms had to be adjusted somehow to address. Okay. And now they are. You can see now, because this is an addendum, it's going to go on the contract. It must go that way. This is not designed to be something where you go and talk to the seller. You don't have to have the seller sign this at the listing appointment. We're going to talk about that in just a second. Okay, I'm going to talk about how this fits into the new to the changes in the listing agreement. Okay, but it is really designed to be something that is negotiated and something that when it comes to the seller is going to authorize you. This is the changes in Form 101. You can see here in paragraph 7C. You can see here what's missing right here in the new 7C is a checkbox for the listing firm to offer compensation. It is just the seller. So now that the seller has authorized you to advertise an amount of compensation, if any, could be zero. But if the seller has authorized you to do that as the listing firm, this is where the seller is giving you permission to advertise whatever that is to cooperating agents, to potential buyer agents. Okay. And you can do it here. You don't have to have them sign this in advance. Because one of the things you want to make sure is on the listing side is that you want to make sure that you're not promising compensation. It always comes and it should come with a qualifier of this is potentially out there if there's a qualifying offer. If you're making a blanket offer of compensation, that's fine. Some of you may remember that the way the MLS worked, it was a blanket offer of compensation, and it did depend on how the contract was signed. So it's no matter how you slice it, that's how it's always operated one way or another. My point is that a lot of times you guys with the old 220, and because of the different check boxes and the different ways it could be done, one of the things that listing agents have done previously is have the seller sign 220 in advance. That is no longer necessary. It's just not. Now that we have this addendum, it is just something that can go along and be negotiated with the contract, and hopefully there should be a lot less of those scenarios where there's a question of whether you're under contract or not because there's been some sort of change to the compensation when the contract is being executed. Okay. So as part of this, I already been over here, but let's talk about this just a little bit. So in 7C here in the changes, you can see that there's still the first two check boxes of whether the seller does or does not offer compensation at all. Okay. And if they do, then they can do that. So now let's talk briefly about with this change in 220, what if your firm wants to keep doing it the way that it is in the current form? Right here, okay, where the firm is authorized to offer, you want to use the existing 220, things like that. You can check this second box, and then you can offer as a firm compensation however you want. However, there's not going to be a 220 that will help facilitate that. That will be something that if your firm does it and your firm has always been the one to offer the compensation, then this is going to be a change. So now, without even checking the chat, there might be some question of why in the world did you do this? Fair question. Fair question. So let's just talk about that real quick. All right. And you don't have to agree with me. You don't have to shoot the messenger. Like I said, the Forms Committee, Joint Forms Task Force, they're the ones that vote on this stuff. I don't go out and, hide somewhere and then just pop out every summer and, give you guys the forms changes. This is an ongoing year-long process that involves dozens and dozens of really good people who volunteer a lot of time and have a lot of discussion. Okay. So these things are not decided in a vacuum. There is a trend right now nationwide. Okay. And we are only just now going to be joining the majority. And I think the majority is in the right place. But there is a trend nationwide to either ban, like outlaw, like governments taking action to outlaw firm to firm compensation, or to take some sort of action where firm to firm compensation is just not available in the forms anymore. Why? It is partly trying to look to the future and see, all right, we've had these changes to the MLS rules, we've had the settlement, we have all these other changes. What is the next landmine? Where are the next, potential areas that could be a problem? And this is a problem. It simply is. The nature of firm to firm compensation is something that just needs to be addressed, and it is something that already a majority of jurisdictions have addressed. So NC Realtors will be joining that. And the default will be that the seller will be the one authorizing a potential, concession for buyer agent compensation. And if the firm wants to continue to do it, you have a checkbox here, create your own custom addendum, or and if when it comes to an actual agreement, you would need an actual, custom agreement for that. Except that there are some in the commercial forms library. If you want to talk about, if you want something to look at to potentially to go by, there those forms are still in there. I want to say it's 541 or 542, maybe both. I can't remember off the top of my head, but I think that's right. In any event, you can look at those if you want like a go by or something to use, something that could help you in that space. However, it's just something that if you just want my 2 cents, and this is just me personally, I'm not speaking on behalf of NC Realtors for this, but if you're just asking my opinion personally, when I'm like you guys, I go in, I read Inman, I read these trade magazines and articles, I read about the current trends, the current lawsuits, and to me, there's no question in my mind that this is a better way to go, especially if you're a big firm that has some exposure. If you're a small firm, do you have as much exposure? I don't know. I mean, I suppose you could. I mean, it's just something where, how big is your footprint, right? Like how big of a target are you, I guess, if somebody wanted to pursue some kind of legal action in this space. It's just something to think about, something to, if talk to your lawyer about it, and figure out whether it's a good fit for you. But there's a reason why, this has been this shift. One, it's going to be massively easier and simpler. If you look at this new 220 compared to what you guys are dealing with now and have been dealing with the last couple of years, this is certainly easier. Easier to fill out, easier to understand, and it is simply something between the buyer and seller. There's no other, parties involved, no other parties to even sign. Same thing here. It is just something for the seller to think about. And before, it was these little Romanettes that are up here. This one in particular, I don't think people paid attention to because the firm, even under the existing Form 101, doesn't actually pay. It's the seller. You can see right here, it's written in this language. The seller agrees to bring that to the firm for the firm to turn around and pay at closing. So to me, it's one of those things where the difference between these first two options, there is, as far as who the actual contracting party is, yes, there is a big difference. It just is a difference. Is the firm going to be the one obligated to pay the compensation to the buyer agent if it's agreed to, or is it going to be the seller, right? So the contracting parties, obviously, it's a big difference, especially when you're talking about anytime you check the seller box in the current existing 220, anytime you check that seller box, they're going into a direct contractual relationship with the buyer agent. And I know for some of you, that's been something that has been a point of discomfort because what happens if your seller breaches? What happens if your seller does something that, to expose themselves to some liability at the closing table? Well, now they have this contract directly with the buyer agent that could expose them to some liability. Now, the firm also could have some liability depending on the circumstances, but that's just a big difference between the two, especially if you've got that scenario with a seller. Okay. All right. We're going to talk about other things, other changes in Form 101 later, But as far as how 220, the new 220 is going to be working in with your listing appointment, this is what it looks like. And for those of you who want to continue to make it a firm offering of compensation, then that's something where you talk to your attorney and or draft your own and have an attorney review it, and then go ahead and do it and attach it to Form 101 as you go forward. As I said, do I think that is the best way to go? Based on the national trends, no, I don't. But if that's the way you want to operate, you still can't. It is not illegal in North Carolina yet. And I'm not aware of anything, any pending legislation that would affect that right now. However, in other jurisdictions, it's already happened. So, in any event, all right. So let's move on from that and look at the contract, because here you can see that seller concessions remains pretty much unchanged. So when the new Form 220 talks about in addition to other concessions, it is talking about this right here. Okay. So it may well be that the seller wants to give a credit for blinds or new carpet, things like that, in addition to any potential buyer agent compensation. Understand that these two numbers are in addition to each other. Okay. So make sure that you are specifying that correctly. You don't want to put, some double or whatever. I feel like at first there was a struggle with 220 to get that, to get that right and figure that out. And for some people, but it seems like lately there hasn't been as much confusion on that. So I'm hopeful that people will understand that, especially with the language here in the new 220 that makes it clear, hey, this is in addition. So don't be putting it down twice. Okay. Although every once in a while I do get hotline calls where there's a mix of both, depending on the loan package or what the lender is saying and things like that. So, these things are things you can use, but in harmony with each other, but make sure they're in harmony. Let's not have disharmony. If your home life is like mine, it's straight up chaos pretty much all the time. And I don't even have dogs. Those of you who have dogs, I don't know how you deal with that chaos. But anyway, I'm just saying that, make sure that they are working together. All right, so let's start with the other changes to 2T and talk about some of the new addenda and major changes to other addenda that are in this form. Here at the top, this is actually not something that is a major change, okay? This is mostly to simplify things and to help make it create space so that we can fit more things on the first page when the strikeouts are taken out. So if you go look at the new 12T, like if you go over here and if you want to look what a clean one looks like, you can click on the 12T. Where is it? It's down here. Here we go. And you can see kind of what it looks like when it doesn't have the strikeouts. It's quite a few things that get onto the first page there. So that's really what this change is about. Here, you have changes to the purchase price, taking all that capitalization things out there, making it a little bit easier to read and understand. In the final, it'll look much cleaner, much easier to read. It'll much like this. It'll fit a little bit better. But interestingly, this is 12T again. Sorry, I moved over here, but you can see what it looks like when it doesn't have all the strikeouts. One thing that is in here, though, is you have the due diligence fee, and you can see the due diligence fee is due on the effective date. Okay, why am I bringing that up? Everyone's like, so what? It's always been due on the effective date. What are you talking about? I will tell you what I'm talking about. It is down here. Okay, why? Don't do that. Don't do that. Okay, there we go. All right. Here we have a change to the due diligence fee paragraph, and it is in here. In particular, this sentence has been added in, and some of you are really going to like this. Probably most of you are going to like it. But it says, as stated above, the due diligence fee is due on the effective date, and it must be delivered to seller no later than the next banking day following the effective date. It should be the property seller upon the effective date and should be a credit to buyer at closing. What does that mean? It means that you no longer are you going to be in a scenario where you go under contract on a holiday weekend at 7 o'clock on a Friday night, and then your seller's in breach Saturday morning with no ability to get into any bank until Tuesday. All right. That is not going to happen. Banking day is defined. We're going to get to that later on in the form. So there won't be any confusion about that. But going forward, the due diligence fee is due on the effective date, and it's the property of the seller on the effective date. All that. So that means the mechanics of things like the buyer goes under contract and the next day wants to terminate for no reason other than they have buyer's remorse or just a regular old case of buyers be nuts. Okay. They just are. You guys give me, for all I know, all of you, just all your buyers. I don't know. I don't know how they even got to the decision that they wanted to buy a house with how they act sometimes. You people are saints for how you deal with those buyers. But anyway, in this case, you won't have that. You still will have that scenario where if you have a buyer who has, buyer's remorse the next morning, if they terminate, that fee is still technically due to the seller in most cases. Obviously there's those scenarios where a buyer might, claim that there was a misrepresentation or something like that. I'm not talking about those cases. I'm just talking about a buyer who wakes up the next morning, doesn't like that they signed, and then wants to get out of it. Okay, and we get their money back, or maybe they lost their job or something like that. Technically speaking, in most of those scenarios, the buyer is still going to be, the seller is still going to be owed the due diligence fee. Those cases do not change. What does change is that the buyer will have until the next banking day following the effective date to pay and not be late. Okay. And if they fail to do that, you can still use Form 355 to demand the money. And if they don't pay the money, then within one banking day, then the seller will be able to terminate. So, what's going to happen in some cases is simply going to be that the buyer's going to get some extra days. One of the things that I tell listing agents pretty routinely on the hotline is don't if you give grace to the buyer on the due diligence fee, which you can, understand that those statements are often binding. Waiver is a real thing. It is a real concept in the law where if you waive parts of the contract, let's say you got a right to something in the contract and you decide to waive your right, oftentimes a court will uphold that. Will it every time? No, not necessarily. But it is a thing. And when you guys are acting as agents, if you're acting within your scope of authority, the things you say matter. Okay. And so you need to be careful with things you say. And what I'm getting at specifically on this topic is this: when I get a call from the listing agent on the hotline and the buyer, is 2 weeks into the transaction, the buyer doesn't pay the due diligence fee, and then the listing agent will throw in, calling about something else entirely, and then we'll throw in, well, they didn't even pay the due diligence fee. Well, did you demand the due diligence fee in writing? Okay. So just understand that you're already going to have, in some cases, an extra couple days built in now because of this new thing where you have until the next banking day following the effective date to make that payment if you're the buyer. So because of those extra days built in, I think as a listing agent, you really need to think about how much grace am I going to give a buyer who's not paying on time? If they've not paid on that next banking day, if they haven't delivered, sorry, on that next banking day, then how much more grace am I going to give them before I give a written demand that they pay the money to help trigger the seller's ability to terminate and move on if that's what they want to do? Make sure you talk to your sellers about that. That is something that they likely are going to want to talk about. Okay. All right. Let's keep on going and just talk about some of the other things in here. All right. Effective date, that's just being moved, I believe. I don't think there's anything. Nope. I don't think there's any big part of that. Some of these things are just, because they're moving around, not necessarily because there's a big change. Today, I'm going to be covering all the big changes to the extent that I can remember them. Just kidding. I live in these forms. I'm not sure I can forget them if I wanted to. It would take me a very long time to deprogram from where I'm at now. At least that's what my therapist tells me. Anywho, home warranty, which used to be buried later on in the contract, has now been moved up to, it will be now on the second page. So look for it there. You can see that this has also been simplified from the current version. No other big changes on this. So just understand that. But Yeah, the home warranty now will be on the second page, so you're not gonna have to flip through a bunch of pages to go find that. Farms Committee has been really, really good and thoughtful about how they're moving things in the contract to try and get things closer to the beginning of the front page, just so it's easier for you guys to work out, to look at and not too difficult to find. Moving on down. We have a technical change here, but it's something that anytime there's a material change to the funding, that's going to be a material fact that has to be disclosed. A lot of times, there's a hotline call. The listing agent will call and say, "Hey, they're moving from, say cash to conventional. Is that a breach of the contract?" The answer is maybe. Sometimes I think it could be. It's almost always going to be hard to prove. But if a buyer tells you, "Hey, I'm paying cash," but they have no intention of paying cash, then yeah, you could argue that that's a couple things. One, it's a misrepresentation. You could argue it's fraud, but two, you could argue that it's a breach of the duty of good faith in the contract. A duty of good faith is implied in every single contract under North Carolina law, whether it's specified in there or not. You have to act in good faith. So because of that, that's something where, yeah, you can make those arguments. They're often difficult to do. The biggest one is if a buyer wants to go from a conventional loan to FHA VA, the seller has no duty to sign that form if they don't want to. So it's often hard for the buyer to make that change if that's a change that they think they want to make. But in any event, they are material facts that they got to be disclosed. You can see it used to be down here, but really it's to everything. So that's why Forms Committee moved this language or just eliminated this language and highlighted the one up here and made it italicized. So hopefully it stands out a little bit better to your clients. Here in paragraph 6, there's no major changes here, just breaking out these different sections and giving them some subheadings. So hopefully it's easier to see. Here, you've got information on governmental reporting in FinCEN. Right now, FinCEN, you may have heard something about it, maybe you haven't. But FinCEN is it's a reporting, and if you have heard of it, then you've heard about what a big deal it is going to be. The reporting document that closing attorneys have to fill out is serious and long and involved. So when we are going through this form cycle, one of the things that was talked about was FinCEN, and we got some other FinCEN changes there coming later in the program. But for this one, you can see in the contract, it's not just about FinCEN. FinCEN is definitely mentioned here by name because that's the big one on the horizon. However, you have pending legislation about foreign governments and things like that in North Carolina. If that passes, then this paragraph would also cover that and that affidavit that's part of that statutory scheme as it's, presented right now anyway. So just understand that, this paragraph here, if there's governmental reporting required, then the buyer has to comply with that, give the closing everything. FinCEN, that rule that has been, suspended right now. It's been paused by a judge, maybe even by an appellate court by now. Honestly, I can't remember. But in any event, it has not gone into effect yet. However, that could change at any minute. So, because of that, if your client brings it up now and asks about it, there's some language I'll show you later that you can explain it, but also you can just tell them, hey, right now, the closing attorney is not going to make you do it because it is held up in a court process. But that's that's where that is right now. In any event, the language is more expansive than that. So just understand if other stuff comes up, that's already an obligation of the buyer. We got some technical edits to the lead-based paint. Here we got a small change, but it's one of these, mighty, mighty but tiny, changes. Uh, we commonly get a hotline call. It's like, hey, they haven't paid the money yet. And now they want to get in the house with their contractor and everything else, blah, blah, blah. Do I have to let them in? And I don't know. I think under the current contract, I do think there's an argument to be made simply because, this paragraph here says the seller shall provide reasonable access to the property, right? By the way, through closing, just so we can be clear on that. I've answered that call probably a half dozen times this year, okay? The duty to give access goes all the way to closing. Okay. Closing means the deed's recorded. That means the seller doesn't even own the property anymore, okay? Anyway, so Here you can see there's new language added that says that until the due diligence fee is delivered, physical access to the property may be limited or denied by the seller. So it just gives the seller just a little bit of just a little tool there where if they don't want to let the buyer in, because the due diligence fee has not been delivered yet, then they can do so. Because we were getting a surprising number of calls where buyers would not pay the due diligence fee and try to get in the property. There was times they were getting in the property and terminating without ever delivering the fee at all. And then basically that puts the seller in position of, well, do I sue the buyer for this due diligence fee or not? Is it worth my time to go seek, a legal remedy against the buyer because they failed to pay the due diligence fee? Although, technically speaking, if you did that case, you'd also have a pretty good claim, I think, for the earnest money deposit as well. So it's not just about the due diligence fee in that circumstance. A buyer who goes into contract and then decides not to pay the due diligence fee, they one of the things that you're going to tell them, well, the first thing you're going to tell them is to consult with a lawyer. But we also have Q&As in the library, in the NC Realtors library, that talk about how the buyer's also risking their earnest money deposit. One thing that I don't know how often this will come up with you guys, so forgive me while I get very technical for a minute, but somebody asked a question about it. And I thought it was a good question. So I figured, it's not, no harm in covering it anyway. But you can see here, until the due diligence fee is delivered, then physical access to the property may be limited. All right, well then what about this language up here? Because, we were up here in the due diligence fee paragraph, and there's this language here where buyer and seller expressly, there we go. Buyer and seller waive any right they may have to deny the right to conduct due diligence or assert any defense of the enforceability contract, blah, blah, blah. Okay. And actually the blah, blah, blah that I just did there is really I think the part that differentiates the two, because this section is really talking about any defense or enforceability of the contract based on the negotiated amount or none of the due diligence fee. So you've decided on an amount of the due diligence fee. And what this language is saying is, all right, we've negotiated, either zero or whatever, right, for the due diligence fee. And based on that, you're not going to hold up due diligence. And we have a binding contract, even if the due diligence fee is zero. That was really the biggest thing, is that if the due diligence fee was zero, is there a contract? I know that sounds, at least in my mind, my lawyer brain, that sounds silly, because a contract can be established on an exchange of promises to support it as consideration. You don't always have to have, some kind of fee in order to support consideration for the contract. A promise to deliver title based on satisfaction of being able to come up with the purchase price, among other things. That's an exchange of promises that could also work. It doesn't have to be a fee in any event. So these two things, at least in my view, are two different things. It may well be that Forms Committee will decide, or Joint Forms Task Force will decide to, toy with this language. But for the moment, if you do have a seller who brings that up and is like, what is this even talking about? How come, these two things seem like they don't work? What is it? Then if you can remember this moment in time, you will have the answer. If you can't remember this moment in time, sorry, but you can call the hotline and I'll tell you again. So it's not like I'm like the teacher you can always bug forever. By the way, that blows me away about teachers now. Those of you who like do teaching as a side hustle in school, and your students like texting you at 8 o'clock at night about if they're like my number two daughter, inane things that they probably were told 5 times during class. I don't know how y'all do that. That's crazy. But you all get to do it because, that's just that's part of your member benefits. So, if you want to email or whatever, then we'll tell you. In any event, these are two different things. This point here is talking about the amount of the due diligence fee and whether there's a binding contract or not. And then the part down here is really talking about, well, what happens if that is not delivered? So you're talking about two different points in time and two different things. So in any event, for those of you who have a seller who, wants to use that leverage, not unreasonably, not unreasonably. I will stress again, not unreasonably, because right here, reasonable access, this is still part of it, okay? Also, this is a may, doesn't mean you have to. Just be careful with it, okay? That's all I'm saying. Use it judiciously. Otherwise, we will take it away. No, I'm just gonna, maybe, I don't know. I'll make that decision. That's up to the forms committee. All right. Here we got to change because there was some reporting that some attorneys, when it goes to someone else, in this list, okay, these Romanettes. By the way, you don't have to fill out this blank that's in this paragraph. If you're filling out this blank, I'm telling you right now, 99% of the time, the closing attorney is not even looking at it. Okay, this section was revised a couple years ago so that these Romanettes 1 through 4 capture nearly everybody, unless you have a scenario where two unrelated people are buying and they both want the deed in their names. Then, that's really the only scenario we're going to be filling out this blank here, this section. All right. So it's really something where if you're filling it out now every single time, then you just don't need to be. Okay. In any event, there are some scenarios where even if it was going to some of the Romanettes, then closing attorneys were making the buyer sign an assignment agreement to go to, say, a trust or an LLC or things like that. So we added some language that's saying the assignment's not necessary. However, understand this. It may well be that sometimes the closing attorney will make your client do it anyway, even with this language being in there. Maybe this will cure it sometimes, maybe it won't. But there are scenarios, especially in family sensitive scenarios, where the closing attorney wants a document that is, of legal sufficiency to cover them. Because there are times where, in bad scenarios where, say it's a husband-wife situation, the husband comes in or calls and says, "Hey, by the way, well, we're just going to put the deed in my name on this one." you know, and then the attorney relies on that, and then he's got a whole fiasco when the wife finds out, and it could be post closing. It might be something, how closings are, especially when you got new people. They don't know how things, they're signing the whole thing, right? So it's something that some closing attorneys are like that. To me, that is understandable if they want to do it that way. It is cumbersome, and I get that it's extra paperwork. But as long as the closing attorney is not like charging you a bunch extra for it and it's for their protection, then to me, I'm just saying that I don't think it's out of the realm of craziness. In any event, this language is here to help you in some scenarios if it's something where the closing attorney is just insisting on it for one reason or another. Finally, here you got banking day. It's defined, and like I said, it's defined very specifically. It is every Monday through Friday and excludes Saturdays, Sundays, and holidays observed by the Board of Governors of the Federal Reserve. Um, there you go. I'm not sure how else you could make that much more specific. So that's what a banking day is, in case somebody wants to know as far as delivery of the due diligence fee. Got some technical edits down here, but those are not things, I don't think they're things that you guys need to be concerned with. All right. So that is the offer to purchase and contract. We are not going to do 12T because those changes are all pretty much a mirror of this one. And there are certain scenarios today where I'm not going to cover the non-exclusive buyer agency agreement or the vacant land exclusive listing agreement, things like that. So those changes are all much the same as they are now, or the sister form, if you will. All right. Let's go to the guidelines of the offer to purchase a contract, because I think there's some things in here that are really good. Number one, this language here about spouses having to sign the listing agreement and the contract used to be toward the end of this form, and now it's at the beginning. So if you ever need a resource where you need to show you got somebody arguing with you about whether the wife or the husband needs to sign when it's the separate spouse's independent sole property, here's some language here that'll help you talk to those people about it. Here, you've also got some extra things about the due diligence fee and how that works and about the demand process. Here, you got home warranty that was moved just like in the form itself. Here, you've got a much longer explanation about FinCEN and what that means or infers or whatever. So if you need a resource, if that legislation comes, or there, I think it's a rule actually. Yeah, it's a rule from FinCEN. So it's not a statute. But yeah, if a court, sometime over the next year decides to reinforce that rule, reinstate that rule, then here's the language that explains what it is. And basically, it's a money laundering rule. That's pretty much it. And that's down here at the bottom, but it's to help prevent people from doing that using corporations and other vehicles to commit those sorts of crimes. And that's really it for the guidelines, if you're interested in those. Let's move on now to something that has got a really big refresh, and that is the new construction addendum. I would say, as a hotline call, when people would ask me, here's the state of the house. Do I use the Form 2T with the new construction addendum, or do I use 800T? And 800T, it really is designed to be very, very expansive. We got a big update last year for those of you who haven't used that form in a while, just so you know, we got a big update last year, and I think it's really much easier to follow and use now. Um, at least for me anyway. It's not a form I get into every single day, and the update even helped me in how I could understand it. This forum, though, this year got a big update. And really, there's a subcommittee on this, and they did a really, really good job. They spent a lot of time on this. But there was a lot of discussion of when, is there a way to give more clarity as to when exactly, somebody should be looking at 800T versus the new construction addendum with 2T attached. And you can see it's right here at the beginning. So the note is gone. It's incorporated, later, at least any parts that are still relevant. But you can see right here, if the drywall is done, if the drywall is completed in the dwelling, then that is the point in time where this form makes more sense. Okay. And so you really just need to know one line of demarcation where it doesn't always have to be that way, and clearly it can be preference. There might be some other reasons why you would want to, even if the drywall is done, you'd want to use 800T instead. That's fine. Like however you want to parse that out within your firm, then go right ahead. But as far as how the form is designed and what the form is now designed to facilitate, now you've got, it used to be the new construction addendum was a lot more limited. It was really designed to be like, this house is basically done. Okay. It's a new construction. And so you want like a new construction addendum, but basically this house is done. Well, now this can be used way, way, way much earlier in time than the old new construction addendum was. So let's look at some of the things that are different that make it do that. You got some technical edits here. So I'm not going to go through those. But one of the biggest things is you have a section now for additional improvements, which was not in the old form, and really talking about how changes to that, would require a change order and things of that nature, things that go along with the new construction. Okay. So because that's in here, and now you have, you can see how it makes more sense where, okay, the drywall is complete, but we got a whole bunch of other stuff still to do, right? And so your kitchen plans, general finish and fixtures, these are all things where you could do schedule of allowances. And now you can specify it in here. When it comes to new construction, if you are an agent who has never done one, especially if you're a new agent, please find a buddy. I cannot stress this enough. Okay. Now, there are several members of the Forms Committee who served on this subcommittee who do a lot of new construction. And honestly, every time they started talking, my eyes just glazed over. The amount that I don't know about new construction is massive. Okay. It's still massive. Okay. And that is why it is very important where if you're an agent, it's your first couple times doing new construction, phone a friend. Okay. Do that. Please, please, please don't think that just because we've made these updates to the forums that now you can do it yourself. No, 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 no. Don't do that. Don't do that. And in particular, when it comes to this section, there's so many things you're going to want to make sure you get in there because these things are going to be incorporated, made part of the contract. And, I don't know, the only, people that might be crazier than buyers and sellers, well, I guess it's a subcategory sellers, can be builders in some circumstances. Like some of the stories you guys have about builders are really quite something. So what I would say is it's always very important that the scope of the work that the builder is doing, that is in there and something that has some kind of meat to it so that the buyer knows what they are getting, what they're negotiating in the contract. So make sure you do that. All right. So here you've got also a deadline here. So you've got like 60 days built in as far as additional improvements, as far as putting a limit on the delay. Some of you who looked at 800T after the big revision a couple of years ago, that was something that was built in, putting deadlines in there to make sure that the delay just couldn't be forever if there was a builder delay. Okay. Here you've got just inspections, you got general inspections, radon inspections, and a new section having to do with punch list items. Okay. So, just like an ordinary part of the construction process, this is obviously brand new to this particular form, but it is something that is in 800T. It used to be something where, especially if you had that, then it might be something where maybe the rest of the transaction doesn't make any sense for 800T, but you really need punch list items. Well, now now you have a mechanism for it in here. Okay. Insulation. Then you've got this movement of this warning, the existing form up here to this language. It'll be in red in the final form. All right. So that's the new construction addendum, and obviously a big change from that. Hopefully, this form will help you guys navigate that area, give you a better option when it comes to a home that has, you're not starting at the foundation. You got a lot more stuff going on in there. Now, in case you didn't really follow all of that, which, I'm sure you did, anybody in this room, we're talking about best of the best. But let's pretend people not in this room need to know what I just said, okay? And the things that I talked about. There is a new 800G, so new guidelines. Technically, these guidelines, they used to accompany the new construction contract 800T, but now they've been revised to really just talk about, all right, you got a new construction. What are some things to think about here? You've got, all these other things. This section here, this might be a section that Forms Committee is going to adjust, this cycle. But I think the language is overall pretty close, and I do want to talk about it real quick. You can see right at the beginning, it says, this guide does not address agent compensation. That's the guide, okay? But part of the reason that you have this blurb right here is because, yes, as I explained at the beginning, you've got changes to 220, and now, you can use that. I'll be curious to see if 220 ends up in some custom builder contracts. I don't know if it will, but I'd be curious to see if that happens. But in any event, a lot of times in new construction contracts, builders will have their own contracts, and a lot of times that will address agent compensation. And another thing too is, as we're going to talk about, there's changes to the agency agreements, the buyer agency agreement about new construction. So we'll talk about that too. But one of the issues, the longstanding issues in the forms library, in the NC Realtors forms library, has been new construction and in particular agent compensation. So it's just one of those things where you want to make sure that your compensation is addressed in your agency agreement for new construction. Okay, you want to make sure that is taken care of, at the get-go when you're sitting down with the client, even if you think your client is going to be buying, an existing home. It never fails that, your client thinks they're going out looking for one thing and they end up getting something totally different. Happens every time. Well, not every time. Every time, some of the time. There we go. I fixed it. All right. In any event, you got the 800G new construction forms guide, and you can see it's got a handy dandy list here. And there's some major differences between 800T and 2T. For example, there's no due diligence fee, right? There's construction fees in 800T, but not in new construction addendum. There's no due diligence period in 800T. So here you got a short, easy list of just all the differences between the two. And it could be something where, you're talking to your seller or you're talking to your buyer or maybe the seller, and you're trying to just decide, all right, well, which contract form do we want to use? Like, what do we feel most comfortable with? And so this is just an easy list to kind of see some of the major differences between the two. Here, you can see it talks much more about the drywall, but also just generally speaking, there's going to be fluctuations between the two as far as when you may or may not use them, okay? And yeah, just a lot of inspections or a lot of just I would say generally applicable things to think about new construction and how these forms work with a new construction contract. Okay. So there you go, new construction forms guide. That is a brand new form this year. It was retired last year, 2 years ago. Can't remember, but it's been brought back. Well done on that. All right, we have another new form right here. We now have an additional parcel exhibit, and you can see right from the get-go, you can see it's number blank of blank, meaning, you can fill out several of these. And where this goes is when you on 2T here, additional parcels, you can see the additional parcels described in an attached exhibit or 2A10-T. Well, 2A10-T is right here. So you can see here on each page, it's one page form, okay, and buyer and seller sign it, but it's got the ability to put two parcels on here. So in addition to, right, because you can see right here, in addition to the property described in the contract, okay? So when it comes to, the contract, these two parcels, if you have this filled out, these two parcels are already in addition to whatever is described here in 2T, okay? So just understand that that is how this works, all right? And also, you can see there's check boxes here. So you can just fill these things out and attach them to one of your listing agreements as well. So you don't have to invent new forms. Like whenever you sit down at the listing appointment, you're doing the additional parcels, do it with the addendum. You can just put that as part of your listing, upload these forms as part of your listing and be like, hey, buyer, hey, buyer agent, these things are going along. Do this, use these things. Okay. And they're meant to be sort of Swiss Army knives that way. So hopefully you guys will find that helpful. Let's move on to the vacation rental addendum. This addendum also got a very big upgrade, and big thanks to the subcommittee that worked on this. They were another subcommittee that was very, very busy this cycle, give a lot of input. So here you can see that you really want to give the subject to the following vacation rental agreements, including those by VRBO and Airbnb. Okay. And the reason for that is in part because you want to disclose, or I guess I'd phrase it this way. If I'm the buyer, I would want to know those. As a seller, I don't really care, because for those of you who don't know, as soon as you sell a vacation rental property, the VRBO, Airbnb, those reservations get wiped out because in the lease agreement slash reservation agreement in those platforms on the sale of the property, that's just what happens. Okay. And the Vacation Rental Act provides that, the rules in there are subject to a lease. So nobody's ever challenged it. I guess there could be litigation there, but to me, it makes sense why there hasn't been litigation on it to this point, simply because that language is in the Vacation Rental Act. Okay. So when we talk about the 180 days and things like that, those are all things that I think can be adjusted by the lease. But I don't know, some litigator might go out there and file a lawsuit to change my entire interpretation on it. So if that happens, I will update my statements about this area. But in any event, so you want to know that, and you want to get that if I'm the buyer, simply because if I'm buying a vacation rental, there's probably at least a good chance that I'm going to continue to operate it. I'm going to want to know, who are those reservations with? Could they be something that go on there? And so one of the big changes in this form is that instead of providing it, you can see down here, within 10 days after closing. So it used to be you would get this list of reservations, if you're the buyer within 10 days after closing, that has now been changed. That's now 7 days within the effective date. So that during the contract, if the buyer wants to reach out to those folks, then they can figure out whether it works with their intended use of the property or not. There's also a really good section here about how you're going to keep things confidential. So if clients get nervous about that, you can show them that language in there. So that's a really big change as well. And then there you go. Don't disclose, but if there does need to be some kind of disclosure, the seller will not unreasonably withhold their consent so that the buyer can talk to who they need to talk to. And if the contract is terminated for any reason, buyer agrees to return or destroy any information provided by the seller pursuant to the paragraph. So These sorts of situations, depending on the circumstances, can be a little bit more sensitive in nature. So, some language in there to accommodate that. Here you've got a paragraph about how to distribute deposits and rents, but you also have blanks here. So you can see that if you want to change the proration, you can write out how you want it to be. That's what these blanks are for in paragraph 3. Okay. So it addresses that. But otherwise, just understand that the proration paragraph in 2T, I'm not going to scroll over there, but a lot of you are probably familiar with that paragraph about prorating taxes and rents and things like that. If you don't put anything in these blank lines down here in this new paragraph 3 of the Vacation Rental Act or Vacation Rental Addendum, then it'll be prorated based on that paragraph in 2T. So it's just whatever it is at closing. There's just that line at closing. The attorney does parses it out either way, and everyone goes in their way, including those reservations that may be wiped out by Airbnb and VRBO. So taking those into account as well. So just understand that this is here. Something that you're going to want to pay attention to. It may be something where you could, those of you who do vacation rental sales and purchases, I feel like are very savvy with this kind of thing because a lot of you, that deal with in that arena are dealing with clients who are much more attuned to or maybe sensitive to tax implications of the sale, right? It's more of a business kind of situation. But my guess is that these lines here are something you'd be able to use to be able to make a deal work better for both buyer and seller. Just depending on how the rents are, how to be distributed, how to be prorated. It could be something where, depending on how you structure that transaction, it could be pretty beneficial to both sides. So just something to keep in mind, these blanks are here and could be very valuable, in a lot of different transactions. Here, there was a change a couple of years ago that added this language it's mostly the same, but the purpose of it is still the same, where it used to be that the form didn't address at all, what would happen to the existing property manager. And then buyer and seller would have these agreements, gentlemen's agreements on the side. And then, of course, they wouldn't be gentlemen about it at all. Not surprising to anybody. Not surprising. Anyway. So what this section does is give that, gentleman's agreement actually a space in the contract where it's in black and white. And you can see here that, the way it was addressed before was that there'd be a credit. But now there's a checkbox option and also an option of, or the default will be that you'll pay for all the damages that the current seller will incur if the buyer does not go with their existing property manager. If they agree to it, they don't have to agree to it at all. That's what the will or will not checkbox for is right there. Okay. But now there's a maximum amount. So what was happening was people were having a difficult time figuring out what exactly that number is in the old blank. And then, the agreement was supposed to be, all right, well, you're covering everything, right? Like you're going to cover all my damages. And then they wouldn't want to figure out the number, or the number would be wrong, or closing would change. And now the number's different, et cetera, et cetera. You can see how, that number could fluctuate wildly depending on, especially if there was like a delay of a month or two. I mean, you're talking about a big, big number. A lot of times this number, a seller could be facing damages of tens of thousands of dollars to a property manager because they are breaching the property management agreement by selling the property. So this is not like a nothing space, okay? In any event, now you can see that instead they can negotiate like a maximum amount if they want. They don't have to, but if they want, they can do it and put that in there in that blank. But otherwise, if they do agree, the default is they will cover all damages that the seller may incur because of their sale of the property and breaching the property management agreement, and the buyer not using the existing property manager, if that makes sense. All right. A lot of this stuff, you can see this note box has been eliminated. And so a lot of this stuff here that has been moved out of the note box, which has been a continuing theme over the last couple of cycles. I expect that will continue more this cycle. As to this form, though, you can see the notes have been eliminated and moved in. All right. Moving on to another new addendum. Here we have a judicial sale addendum. Um, I those of you who've done any, buying or selling in within the judicial space know how different those transactions are. They are massively, massively different, and they can vary a lot from county to county. Okay. So what this addendum does is really goes into a lot of detail about how potentially, not guaranteed, but how potentially those things can be different. And so it's a really, really good guide for you to give your buyer or seller. If you know they're looking at this kind of transaction, you can get it to them, but it's also an addendum. For example, you got here that the due diligence fee, depending on the county, may be refundable, or it's something they can simply negotiate. The buyer and seller can negotiate one way or the other depending on the transaction. So, but that is something right now by default varies widely from county to county. So you've got it here where things like that can be negotiable. And also it just makes more clear that the contract is subject to and subordinate to whatever the rules are in the court, period. Okay. And so that, and also that depending on the circumstances, there's going to be a lot of limitations on these. Like you may not be able to conduct due diligence, or depending on whether the court gives approval or not, which is not guaranteed in any case ever. Although a lot of times they could be more routine than others. Other cases they can be extremely sensitive, and good luck, and may not be something that will be approved. In any event, you have here in this paragraph, seller deliverables and deed, those sorts of things are covered. Like you might be getting a commissioner's deed or a special warranty deed or a trustee's deed instead of a general warranty deed, which is the default in 2T. This was an area where 2T often conflicted very much with the judicial process. However, this is something that was worked on by NC Realtors and the Bar Association. You can see here this is a joint form between those two bodies, and they are very much uh, the input as far as how judicial sales work, very valuable. Anytime you've got something in the judicial sales space, and you can fill that blank in right here at the top, then it'll help you know how to. I would view it as just a list of things to keep a lookout for. Those of you who do these transactions all the time, you know what to look for and how to navigate and all that stuff. A lot of times when I talk to you guys on the hotline who are familiar with these sorts of sales, like your knowledge is very impressive to me. But for those of you who don't do it all the time, I think this will be a very, very helpful forum to help you navigate those transactions. Here we've got changes to 4T, just a couple changes in here that I want to talk about. Here you can see again the warning boxes and note boxes have been taken out. And now you can add a seller. So that's the first checkbox. So you can add a buyer or a seller, and you can remove a buyer or seller. So that completes that whole saga. I think this has been going on for a couple of years now, where we've been trying to make it easier to get people in and out of the contract with 4T. Mind you, it's a big deal, okay? Getting somebody in and out of the contract. It's not a nothing. So, use your best professional judgment, okay? Best professional judgment, okay? Be judicious. But you can see here, the language in here even does contemplate that you may be, adding somebody or removing something at the same time. So there is language in there to accommodate that. And if you do that, just be careful, okay? I'm just saying, be careful. We're giving you guys a lot of very sensitive things here. Okay. But hopefully, there are things that are helpful to you and that you don't have to go out and ask a lender for it or bother the closing attorney, so that they grump at you about something or whatever. All right. All right, here you've got seller concessions and a percentage being added for that. That's a good little change because obviously it's not always going to be a dollar amount. There is a percentage in there already anyway. So now something where you can change that easily. Escrow agent, some technical changes here, but the biggest thing is they save some space and hopefully make that a little bit easier to read and navigate. All right, let's move on to the exclusive right to sell listing agreement. Again, you can see here Form 2A10-T, that is the additional parcels addendum. If you want to use that, by all means, you can use it right here. We got another big change in Form 101, and it's not going to affect all of you, okay? It is something that is in flux everywhere, across the country. So there are some MLSs in the state that have adopted the new rule that NAR published last year about delayed marketing. And so that is something that you guys uh, in some MLSs have an option for. Here in the form, the language is not delayed marketing like NAR put out last year. And so let me just back up just a little bit. So those of you who remember, you may recall last year NAR put out guidance for the MLS rules, and they proposed a middle option, okay, between office exclusive and public marketing. And this middle option they called delayed marketing something something. I can't remember it. Honestly, I didn't like the title very very much. I didn't think that the title fit like what it was very well. But basically, is this middle ground where, exactly like you could see here in this section here, it explains it where you can list the market and market it to participants in the MLS. Okay, but it's not public where it goes out, more broadly syndicated. All right. And that's what this language here talks about. And you can see here that here in public marketing, most publication. So hopefully it makes it clear to the seller that, this is going to be publicly marketed. Here's everything we're doing. It's the most publication, most widespread. Here, this accommodates the new NAR rule, medium publication, where it's just going to be publicized to participants. But also there's these lines here where if the seller wants to customize how they want it, then they can. That is part of the rule. And sorry, the second part of the rule is just something to keep in mind. It's something that I do talk to some agents about, but NAR issued what they called a clarification of MLS rules, which basically said that you could have one-to-one conversations with a broker outside your firm, and it would not trigger clear cooperation if you have an office exclusive listing. Now, what does that mean? I don't know. You will need to talk to first of all, you have to talk to your MLS and see if they even have adopted that rule or not. Not everybody has. So whether this broker to broker, one-to-one, rule is even in effect where you operate in your MLS, that's something you got to talk to them about and see if it's even in there. Number one. Number two, if it is, then they probably have some kind of guidance about what it means. I've seen at least one MLS in North Carolina that has put out some guidance about what that means. So talk to them, be on the same page with them. That is not something that I'm not going to have specific knowledge of in most circumstances. Besides, I'm just running out of real estate up there. Maybe I need to buy some real estate for my brain to hold more of this stuff. But anywho, so here you've got now, instead of just one option, you have three options depending on your MLS. Now, if this isn't an option in your MLS, then it's just not an option in your MLS. And you can explain that to your client if your client asks about it. But there's also ways where you could do it where, honestly, with the way that you can tailor public advertising, it might be something where you could achieve it anyway. Or if your MLS allows the one-to-one broker rule but doesn't have the limited distribution or exposure option, then you can facilitate it or find a way to work on it. Basically achieve the same thing without necessarily the exact language. So, in any event, if you want to know or discuss more about that, that's something to talk to your BIC about. Something you can definitely talk to us about in the hotline. But because several major markets have already adopted this rule, it is now in the listing agreement as an option for your seller. Part of the NAR rule was this language down here where there's a disclosure to the seller. I would not skimp on this if I were you guys, given the all the other factors in the news out there about the industry. I think explaining clearly to your seller exactly how, a more limited marketing approach may affect the kind of offers they get, I think is a very, very important thing. This language does that and talks to the seller about that. You guys are going to want to have a follow-up conversation about that and make sure that they are also clear on it as part of your listing appointment. I just think it's going to be very important going forward. I'm not going to weigh in one way or the other on, seller choice versus limited marketing, all this other stuff. Each firm can do that how they wish. I just think it comes with different, you know, it comes with different benefits. It's a list of pros and cons no matter how you slice it for each one of these three options. Okay. For public marketing, for example, public marketing, if you do public marketing, you are going to get interest in the property that maybe some sellers really don't want. That's just going to happen. Okay. So you guys know that things I don't need to go into details on that. You guys know how that works. So for me, I understand that for each one of these three options, there's going to be some pros and cons. For each seller, it could be different. For me, the big thing though is making sure the seller understands that there could be a real impact on the value of their property and the kind of offers that they get, depending on the exposure and depending on how they decide to market. So just do that what you will, but um, I would make sure that that is clear to the seller. Take as much time as you need to explain it. All right. In 7B, we have a change here. So now, if the buyer's unrepresented, there's a checkbox for that. Notice, however, there's still not a checkbox for dual agency. If your firm has some kind of policy about what the seller should pay, if there's dual agency based on both the buyer agent and the listing agent being in the same firm, then put it on the other fees line. That is still the case. So if you have a policy on that, that is not something you can do. But honestly, for those of you, I mean, that have a lot of different, options, I would just attach a firm fee schedule. I think that'd be the easiest way to do it. Make sure everybody's on the same page. But if everybody gets to, if your agents are of the type and have the authority to do all sorts of other things, then it might not make sense and keep it like this. Just go with what's in the form. But you have a checkbox now for an unrepresented buyer because all of you know that if there's an unrepresented buyer, it's not like you do less work. It's just not like the transaction's easier. So, explain those scenarios to the seller and explain why the percentage here may be different than what is here. Okay. When there's a cooperating agent involved. We already talked quite a bit about the new buyer agent compensation section, but here it is again. Again, I'll just say again, in case somebody missed it earlier, that if your firm is going to offer compensation, you're going to attach your own policy, and you'll have to create supporting forms to go along with that, probably in consultation with your own legal counsel. Do I think it's going to be like some sort of big expensive thing to get that in place? Probably not. But it is something that you'll need to do once the old forms are cycled out, which, as a reminder, new forms start July 1st. Okay, that's when they'll be in zip forms. You have 60-day grace period from there. After 60 days, then the old forms will disappear. So you have a 60-day window there where you'll have both options in the library. Okay. Well, some of you may have heard about, changes, potential proposed changes to dual agency. There's no changes on that yet. So dual agency remains the same for right now. And we will see what happens with that as we go forward. Here we have something for the seller, and I'll just do the reminder that I often do when I'm talking. Please, please, please be very vigilant about scams. We have this language added in here now for the seller must provide valid identification at the time, anytime it's requested. Hopefully that'll be enough to scare off some of these fake sellers, but any of you who've dealt with a fake seller before know they'll do fake notaries. They do fake licenses. There's even times now where they're getting into people's voicemail boxes and stealing their voice and using AI to create the agent's voice to give different wiring instructions to the closing firm or whatever. There's the amount of scams that are out there now is daunting. You've got to be vigilant about it all the time. Hopefully this language gives you a little bit of leverage against these guys, but there is no silver bullet. When it comes to dealing with scams and avoiding scams, you simply must employ all resources at all times. You guys are just constantly under assault by these guys. Here you can see again, there's FinCEN. We've talked about that today, so I'm not going to go into detail on that. All right. We have another form that got a major change this cycle. This is the vacant land disclosure statement. This is the vacant land disclosure statement. It's not required by law, okay? But it is required in Form 12T. So in 12T, if you're using 12T as the contract for the buying and selling of vacant land, then it is something that is down here in paragraph 3D. And this is the form that the seller would fill out to comply with this section of the vacant land contract. Okay, so it works kind of like the RPODs, operates kind of like the RPODs, but it is not required by law like the RPODs. Okay, all right. So here, one of the things about this form, I'm actually going to skip to the current version down here that's crossed out. This is what this looks like. It's a lot of blanks. It's a lot of check boxes. That has all been disregarded to look much more like the residential property disclosure statement. You can see here for each question, yes, no, no representation. You just do one checkbox and you explain. And you can see here it's got a lot of different categories. These were debated heavily within the forms committee. They did a really good job of making sure that the form is simpler, and you can see that's where it ends up right there. So basically, I think the final version of this form is it's either I want to say it's 3 pages, but it's much simpler and easier to use. So hopefully this will be something where it's a more of an invitation for the seller to actually fill out instead of just marking no representation and everything. Don't skimp on these disclosures. Don't skimp on them in your agency agreements, and don't skimp on them when it comes to the RPODs or this form here. Even if your seller is marking no representation, which is their right, even if they mark no representation, make sure you're asking the questions to try and get as much material facts as possible from them. Okay. It'll be good for you. It'll be good for the seller. Moving on to the exclusive buyer agency agreement. Here you have this at the top, which is basically, in telling the consumer, especially that, at least some kind of written buyer agreement is required before you can tour a home. A little blurb here to make it clear. I think it's implied in the current agency agreements, but here now it's being made black and white that they got to comply with the closing attorney instructions in a purchase contract. So if you have any surly buyers, then you need to point that out to them. Wait, what am I even saying? If you have surly buyers, goodness gracious, all of you have surly buyers. Anyway, so buyer agency agreement. Here's some changes to this, and in particular, just trying to make it more clear that whether they've signed something or not, and what exactly that thing is. But the real point is, if they indicate that they've signed anything with another buyer agent, make sure you look at it. Don't take their word for it. Whatever they say, the chances of them actually having a good grasp of what they signed is not great. Down here, as I mentioned earlier, you've got now a checkbox for new construction property and also some accommodating language down here. So hopefully it'll make it a little bit easier to understand when and how, and your right to payment. There are some wonky new construction transactions, depending on the builder and the contract with the builder, where sometimes the buyer agent's right to be paid was not 100% clear. So this hopefully will close that gap and make it a little bit easier for you and the buyer to understand. FinCEN again, but we've already covered that, so we'll just keep on going. Here you got some technical changes to Form 355. The biggest thing is just that there's this language here about timely delivery of the due diligence fee, because there may not be a due date anymore because of the change with that's the next banking day. On the referral agreement, so this is Form 730. Yeah, got it right. Okay. Here you can see that sometimes there's a question of whether the referral belongs to the agent or whether it belongs to the firm. It could be either way sometimes in some cases, okay? And depending heavily on what the firm's policy is or where it came from, where the referral came from, I mean. So here you've got added language where it talks about one, that it's disclosed to the prospect about that payment can be received. But then this language in red says, unless otherwise indicated, the prospect is being referred by the referring firm and not the referring agent, and payment should be made to the referring firm. If you want it to be different, that is the default, okay, and that is new. That is not in the existing form. If you want it to make it different, you have information notes right here. You can write it in, or you can do it on the other line here. There's lots of blank lines to adjust that. But just so you know, to the extent there was any question about this before, there's now a default that has been set. Make sure that, if you and your firm have a different, agreement about that, please put it in writing. And please also understand that if you get in a fight with your old firm about this form, there's only so much we can talk about on the hotline when we have to be able to talk to you and to possibly the BIC of your old firm who you are in a dispute with. That's pretty much true anytime you guys get into arguments with each other. We do the best that we can to be as fair as we can and, to move on, but understand sometimes we are limited by that. New form 760. This form has no yellow on it because it's been completely redrafted. You can see here that it's got selected and waived. There's no more big blocks, but all through here it is a whole list of things, a new list, and you still have the ability to put additional services. A lot of thought was put into this form, but you can see here just based on the number of new things that are in this form, when it comes to liability, may be one of the most important forms you fill out in your transaction. Make sure, and it really was redesigned with that in mind, so that you guys have something in writing about what your client has or has not waived. Because you all know or have heard or had friends who've been through some kind of ethics complaint or real estate commission complaint. And it's amazing what kind of selective memory your clients have about your transactions. Having this in writing about what they did or did not approve is really, really, really important. So make sure that you do that. Finally, I don't usually cover things from commercial or property management in this, but I thought this for this group, you guys might want to know this. There's a new form 418. So it's in the library right there. It's in the property landlord tenant property management section, which is the 400s. But there's a small claims summary ejectment flow chart. And if you anytime you got like a landlord, or maybe you guys even have your own properties, because I get plenty of calls from you about your own properties on the hotline. So if you needed just like sort of a one pager, well, it's really 2 pages with some additional information here on the back about some common questions. But just so you know, Form 418 is in the library. It's a brand new form this year, where if you have some questions about just the basic nuts and bolts of how to get a tenant out of the property, this is something that may come in handy for you guys uh, as you are going through that particular process. I'll turn it back over to you, Savannah.
Thanks so much for everyone joining. Just a reminder, we will be sending out a copy of the recording and some additional links in our post webinar email in the next day or so. We will also add this to our YouTube channel, and I might just make John re-record it because I feel like it. But thank you, John. We really appreciate you, and everybody have a great day. Everyone have a good one.